Thank you very much for attending the Asan Transitional Justice Conference. Before we begin our session, I would like to introduce our opening speakers. First, I would like to invite to the stage Ms. Ellen Laipson, who is President and CEO of the Stimson Center. Please give her a big round of applause.
Good afternoon, everyone. I'm delighted to have the honor of opening Asan's first major conference in Washington. We've been very pleased here at the Stimson Center to be providing some space to this exciting and important Korean think tank and policy institute as it establishes its presence here in North America. We're also honored to be one of more than a dozen American organizations, both think tanks and NGOs, that are hosting Asan Leadership Academy Fellows. So we're really pleased to have Asan represented here in our community of think tanks in more ways than one. Tomorrow you'll have the president of Asan, Chaibong Hahm, will be in town. I know he's en route now. So you really have me as a substitute, if you will, to say some words of welcome and to just identify the importance of the topic that the Asan Institute has picked. I've been running a think tank for over 10 years now, and I know that think tanks always want to be policy relevant. They want to be focused on things that are very much in the moment, that are current, that are newsworthy, and they want to have impact on current policy. But I think the Asan Institute has picked a topic that is both timely and strategic. Sometimes think tanks have to work on things that are not yet current policy, but that are long-term aspirational or strategic goals. And it's important that non-government experts spend some time reviewing and revising their thinking and the state of knowledge about topics that are not yet at the stage to be implemented or executed. So I was very impressed at the topic that the Asan Institute picked for their opening meeting. As we all know, the relationship between South Korea and North Korea is not moving happily on a path to some kind of reconciliation or even unification. There are many, many obstacles in the way. But how interesting to talk about what would it take and what are some of the experiences from other reconciliations and unification processes. So over the next day and a half, you'll be hearing from a wide variety of international experts on this topic. It has, as I said, both immediate consequence for the politics and the stability of the peninsula, but really is going to play out over a very long period of time. So it's a topic that's worth coming back to every few years. So I wish you all success. I hope it's a very productive and meaningful conference for you all. And again, thank you for coming.
Dr. Laipson, thank you very much indeed for your welcoming remarks, and thank you very much again for providing us this facility. I am Chaun Shin with the Asan Institute for Policy Studies. On behalf of Dr. Hahm, the president of the Asan Institute, it is my distinct honor to welcome you all to this professional event. Setting aside the significance of the topic of this conference, anyone in this room who knows the Institute may agree that the conference will be an important milestone in the history of the Asan Institute, because it will mark the first event that the Asan Institute in Washington, D.C. office hosts in collaboration with the Asan Institute in Seoul, the main office. As you saw on the video clip, the Institute is only a 5-year-old independent and non-partisan think tank based in Seoul. However, it is growing rapidly with a clear mandate to undertake policy researches for the purpose of fostering domestic, regional, and international environments that are conducive to peace and stability on the Korean Peninsula, as well as Korean unification. Distinguished participants and audience, the peace and stability on the Korean Peninsula has recently been seriously threatened by the two challenges from North Korea. One is the North Korean nuclear program, and the other, which has not drawn so many attentions from our international community so far, particularly from the South Korean public, is the systematic, widespread, and grave violations of human rights in North Korea. The recent resolution of the United Nations Human Rights Council established a commission of inquiry to investigate such human rights violations, and further appointed Michael Kirby, Marzuki Darusman, and Sonia Biserko as 3 panel members to examine reports of prison camps, torture, and food deprivation reporting back in March 2014. This will be conducive to raising the public awareness on human rights in North Korea, and I hope this conference will also be conducive. Taking the two challenges seriously, the Asan Institute hosted the Asan Nuclear Forum, convening over 300 foreign and domestic nuclear policy experts in Seoul in February this year, and has decided to host the Asan Transitional Justice Conference here in Washington, D.C. However, you may wonder, rather than dealing with the current situation of human rights in North Korea, why at this critical juncture the conference focuses on the violations in the context of transitional justice. Ladies and gentlemen, if I dare to answer the question, it is because we are more interested in the practical implementation of human rights than another rhetoric of condemnation. Therefore, if we focus on the aspects of practical implementation of human rights in North Korea, I came to conclude that the implementation will be achieved only in transitional period in North Korea, I mean either in time of Korean unification or regime change in North Korea. Against this backdrop and assumption, we gathered 20 scholars and practitioners in human rights and transitional justice to discuss what lessons we should learn from the relevant cases and to embark on feasible study of the application of transitional justice to the case of post-Korean unification. Bearing this in mind, before moving to the first session of this conference, we have honor to invite 2 eminent persons in human rights and transitional justice. First, Ambassador Robert King will make special remark for this conference, and then Professor Ruti Teitel, will deliver a keynote speech on transitional justice in a global context. Ambassador Kim became the special envoy for North Korean human rights issues at the Department of State in November 2009, following confirmation by the United States Senate. He works under Ambassador Davis and has the lead on human rights and humanitarian affairs. Let us welcome Ambassador Kim with warmest applause.
It's a great pleasure for me to be with you here today. I want to thank the Asan Institute for Policy Studies for hosting this conference and bringing together such a distinguished group of experts on North Korea, on human rights, and on transitional justice. As the Special Envoy for North Korea human rights issues, I'm pleased to join you today and extend my welcome to all of you. I'm not here to dispense great wisdom. I'm here to hear what you have to say. There's great value in think tanks. There's great value in people who have the time and the commission to think about these issues in a longer-term context. It's difficult to ask people who are daily trying to deal with foreign affairs issues on behalf of the United States government to think longer than the next press cycle. And so I value what you do and how you contribute to what we do and what we think and what we try to do. Since November 2009, when I assumed the position as Special Envoy for Human Rights Issues, there have been significant changes in the DPRK. The death of Kim Jeong-il, the subsequent rise, power of his son Kim Jong-un. Unfortunately, however, one thing has not changed. The human rights situation in North Korea remains deplorable. The human rights issues are a core part of our policy towards North Korea. The fact that the United States has adopted and twice extended the North Korea Human Rights Act is a testament to the importance of human rights to the American people. One important element that has already been mentioned deserves special attention, and that is the creation of the UN Human Rights by the UN Human Rights Council this March of the Commission of Inquiry to examine grave, widespread, and systematic violations of human rights in the DPRK. The recommendations which the Commission will present to the Human Rights Council next March will be important in developing a process of accountability that will be relevant either with or without reunification. We have urged and we continue to urge the DPRK to cooperate with the Commission of Inquiry. Let me make clear the United States is not seeking as a policy regime change in the DPRK. We are urging the DPRK to change its behavior, to change its policies, including addressing its dismal human rights record. We look forward to the day when we can have substantive discussions with the DPRK on steps that it can take to improve its human rights record. Until that time, however, there's value in thinking through some of the medium and longer term issues related to reunification to ensure the development of a fair and transparent judicial process to address human rights violations perpetrated by the DPRK. This is a great opportunity for seasoned North Korea watchers, and I'm pointing at you, not at me, to provide, from your experience and from your studies, what we and other countries can do in terms of dealing with human rights in the North Korean context. It's important that we discuss these human rights issues. It's important for the 100 to 200,000 North Koreans who are incarcerated in the expansive network of political prisons, and those whose family members have disappeared without explanation, those with Lo Sung-boon, whose ancestors were not sufficiently loyal to the Kim family and who've been systematically denied access to education and employment opportunities. We need to look at the human rights situation in the DPRK because of these people and the abuses that they suffer. The DPRK has a choice of investing its resources in feeding and educating its people, or continue down the path of isolation. We would welcome meaningful measures that would improve the lives and well-being of the people of North Korea, and I'm hoping that we'll be able to find ideas and opportunities from the discussions that we have today and tomorrow that will help us in terms of preparing ourselves and finding a way forward that we can advance the human rights in these circumstances. Thanks very much for your commitment to these issues. Thanks very much for participating in this conference. I look forward to hearing what you have to say. Thank you very much.
Thank you very much, Ambassador King. Well, actually, this conference is co-organized by the Center for Foreign Policy and the Center for International Law and Conflict Resolution at the Asan Institute. This will not be one-time event, which means next time I think, the conference will be hosted in Seoul. So we will invite you to Seoul for the next occasions. Anyway, we have an opportunity of having very eminent scholars in the field of transitional justice. Professor Ruti Teitel, our keynote speaker, she is Ernest C. Stiefel Professor of Comparative Law at New York University Law School, and she is the author of Transitional Justice, which was published in 2000 by the Oxford University Press, and she authored many articles and book chapters on international and comparative law, often focusing on political transitions. She is founding co-chair of the American Society of International Law interest group on transitional justice and rule of law, a life member of the Council on Foreign Relations, and a member of the ILA International Human Rights Law Committee. Please welcome Professor Teitel with the warmest applause. Thank you.
Thanks very much for that very warm introduction. And I'm also thankful to Lisa Collins and to the organizers, the Stimson Center. It's really my first exchange with the Asan Institute, and I look forward to learning a lot in the next day and a half. So my remarks go to the globalization of transitional justice. I've just come back from Jerusalem, where I'm chair of a colloquium on transitional justice in the region. There are obviously a lot going on in the Arab Spring. I'm originally from Argentina. There are human rights trials going on more than 30 years after the fact in Argentina. And I could go on with the current politics. But what I want to talk about today is the way transitional justice has changed since I coined the term in 1991 in a grant to the United States Institute of Peace, where I wanted to study the collapse of the Soviet bloc and the new transitions in Latin America. In proposing this terminology, my aim was to account for the self-conscious construction of justice, and one that was associated with periods of radical political change following oppressive rule. Today, of course, we see that an entire field of inquiry has resulted. Conferences like these, journals with the name Transitional Justice, many books, etc. One can't be helped but be struck by the humanist breadth of the field, concerns in law and jurisprudence, ethics and economics, criminology, etc. The scholarly agenda also reflects ongoing developments in the phenomena of transitional justice. As mentioned, justice-seeking efforts throughout the world. It's interesting to note that in the revolutions in the Middle East, the signs were for accountability, not necessarily democracy. There are ongoing debates about the issues of accountability versus impunity, many institutions dedicated to prosecution, new tribunals, both regional and international, as well as truth commissions. Now, to appreciate the road traveled, one might return to the late 1980s and early 1990s, when the modern-day notion crystallized. And at that time, the debate over transitional justice was associated in particular with a particular question, which was punishment versus impunity. And I was invited at that time to the Latin America project of the Council on Foreign Relations. I wasn't a member. I was recent attorney, and asked, because of my language skills in Spanish, to address the issue of whether Latin American, the new states, successor regimes in Latin America, needed to hold trials in order to be democracies. And I thought, well, this is an interesting, very difficult question for people on the ground. Why is this something that we need to decide? But, got into it. And I, at that time, and in probably what was one of the most difficult 10 pages, they had a 10-page limit, as I recall, I advocated a more expansive view of the rule of law and indicated that there were a number of options for the predecessor regimes, particularly because the judiciary at that time were highly compromised in Argentina and Chile and Uruguay. They were holdover judiciary, and there were other aspects that went to the question of whether this could stand for the rule of law. Again, with the collapse of the Soviet bloc, it became evident that this feature, this case-by-case national struggling with these questions, would become the preeminent characteristic of transitional justice. In fact, the structure of the legal response was inevitably shaped, I argued, by the circumstances and parameters of the associated political conditions. Justice was transitional. It didn't reflect the ideal. And moreover, we learned in such hyper-politicized moments that the law operated differently and was often incapable of meeting all of the values that we associate with the rule of law, i.e. general applicability, due process, substantive values of fairness, analogous sources of legitimacy. So that was the context then, and we might reflect back on the evolution of transitional justice over the last 2 decades. And this is essentially the beginnings of the 21st century, and what I want to propose is really a global phase of transitional justice. Now, let me throw out 3 dimensions or ways we might understand transitional justice to have become globalized. If the prior struggles in Latin America and places like Prague and Budapest, where they had to wrestle with these issues, what would it mean, what kind of truth, what kind of vetting, etc., the global phase is defined by 3 significant dimensions. One is that we're no longer talking about exceptional transitional responses, but rather steady-state justice. And that is that, and this ties into the theme of this conference, that transitional justice is no longer the purview of or associated with one moment of political transition. It's not associated with revolution necessarily, but rather has become entrenched in human rights documents, has become the subject of treaties, has become the subject of decision-making in a number of tribunals. If we think about the Inter-American Court of Human Rights, they have supervised the transitions in Latin America over the last 5 years, and in some cases before. And so it's associated with a much broader set of phenomena. We see transitional justice operating ex ante, before the transition, during the transition, intra-transition, and ex post. And so some examples, of course, would be for example, and again, it may not be a favorite one, but the war in Iraq, the occupation trials. We think of Kosovo and the International Criminal Tribunal for the former Yugoslavia, where the Security Council ordered a commission. There wasn't authority for military intervention at that point, but ordered first a commission of experts to supervise and to investigate accounts of atrocities that had been brought home by newspaper reports in the region, and then this led to the tribunal. So this happened during the conflict. It was known as the opposite of victor's justice because it was unclear at the time who the victor would be, but rather a segue into what we see today, which is the focus on victims. So we have this steady state, ex ante, in bello, and ex post form of interest in justice. This has affected international law. It has affected international humanitarian law, where many of the issues that were associated with post-conflict have now, if you will, are associated with this other discipline of transitional justice. There are, areas that are the subject of human rights, that are the purview of interest by civilians, not just combatants, and it's affected international law generally. The next dimension here, and I just want to say that the UN has registered this change. We can see recent Security Council resolutions which tie together the interest in post-conflict rule of law and transitional justice, in particular Security Council Resolution 616 in 2004. Now, in addition to that aspect of globalization, the second is the fact that the actors who are involved, actors and institutions, are no longer just the state itself, right? If we imagined, and maybe this was a romantic view, that there would be an internal deliberation that took place within a state, right, where all of the stakeholders would be present, and that would either take place either through peace negotiations or constitutions, as was the case in South Africa, right, the leading example of 20th century transitions. Today, given the globalization of these issues, we see that many of the actors are not state actors, but rather either civil society, sub-state NGOs, or transnational actors, the role of the UN, the role of the Security Council, the role of judicial institutions, the role of diasporic communities. And so this reflects a far broader array of interest in the subject of transitional justice than the way we imagined those conversations and those debates about punishment and impunity taking place in Latin America. And so, therefore, we can see that there's a much more complex set of policies and role for transitional justice. Many of these actors don't see eye to eye. The interest of victims, it doesn't, isn't on all four corners with the interest of other actors, whether the UN, this interest in security, or other transnational institutions. The now historical punishment and impunity debate has given way to a demand for judicialization and tribunalization at the global level. There's a call for complex forms of accountability associated with the rise of private actors implicated in violent conflict. We know paramilitary, warlords, military contractors. And so this too has, is another sense of globalization. The privatization of conflict has also affected what it takes to think of accountability in these moments. Now, given, this is the third dimension really, is what is the relationship between the local, right, and these other actors, these other interests that are represented by transnational institutions, UN, judiciary, and other communities that have interest in these issues of justice. And there are many debates that have really resulted. We can see that there are ongoing discussions in places like the Balkans still about the merits of having a transnational tribunal. In other places, the debate is framed in terms of conflict or in conflict of interest, peace versus justice. I want to suggest that there's a broader lens with which to appreciate the impact of the globalization of transitional justice, one which goes beyond any one of these institutions and beyond any strict retributive or deterrent effect. And that is that, as has been articulated by a number of courts that are applying current law, for example, the appellate chamber of the ICTY, the law must serve, quote, broader normative purposes in light of its social, political, and economic role. And so I want to argue that there's a broader normativity, and we could almost see in this period an articulation of a demand for accountability and perhaps even a, quote, unquote, right to accountability that has emerged in the last decade. The normativity is not one that's relegated only to courts, but it has affected political discourse. We can see decisions being made regionally in Europe, for example, where compliance with the UN Tribunal is seen as a benchmark of greater European cooperation. Similar signaling is indicated in Latin America, where compliance with the Latin American, the Inter-American Court of Human Rights, is seen as an indicia of cooperation in the region and general adherence to international law. This may well help explain the last decade's proliferation of transitional justice phenomena. I would say that transitional justice now has become a critical element of the post-conflict security framework, its normative effects are seen as having the potential of fostering the rule of law and security on the ground. Now, of course, this is a delicate proposition. It's often unclear at the time. It doesn't follow a linear chronology. As the UN has put it in a recent resolution, this is from UN resolution in 2004, quote, "Justice, peace, and democracy are not mutually exclusive objectives, but mutually reinforcing. Achieving all of these in post-conflict will require, quote, careful planning, careful integration, and sometimes sequencing." And they talk about the importance of not ignoring victims or civil society, not applying one-size-fits-all, but rather the importance of supporting national assessments, national participation, needs, and aspirations. So this is the sense, is that the UN must support domestic reforms as well as capacity for justice, and that this should avoid really this kind of artificial dichotomy of security versus justice. And in fact, scholars of human security know that at bottom, the security that is needed to return to a war-torn region is not just economic security and environmental security, but knowing that crimes against humanity and attacks on physical integrity will not be repeated. So again, this is being worked through a number of institutions. The view that peace and stability on a long-term basis requires some modicum of the rule of law and assurances of human security. I elaborate this more in a recent book, Humanity's Law. So these processes now serve multiple values. We can see that there is no one necessary response to repressive prior rule. In the region that we are concerned with today, it's interesting to note that even on a postponed basis, the extraordinary chambers in the courts of Cambodia dealing with the Khmer Rouge, Pol Pot regime leaders responsible for atrocities. The view is that these crimes against humanity, even if they were perpetrated years ago, form the basis for reconciliation if they are addressed. That there is if you will, a standard of human behavior beyond which reconciliation is not possible if it's not acknowledged and addressed. You also have similar delayed trials, as I said, throughout Latin America. So the question now is, as I've mentioned, is no longer this view that this is a national problem, but rather a broader international commitment to human security. It's not straightforward. It's not just one layer or linear. As I've mentioned, decades later, this is still being addressed in Latin America, in Europe, and we are seeing a true struggle with these issues in the Middle East, Tunisia, Libya, and so on. I just want to, as I'm coming to the end of these comments, to suggest the importance, and I've mentioned before that one of the elements of the globalization of transitional justice is the role of global civil society and NGOs and foundations of the type that Asan represents. Reflecting on the current global politics of transitional justice will illuminate areas of foreign affairs controversy where claims to transitional justice could well change the structure of the terms of discourse. We saw this to some extent in the struggle over Mladic between Serbia and the EU. There have been recent steps towards negotiating the Turkish-Armenian genocide question in light of a broader context of Europe. And so we might think about a re-regionalization where transitional justice discourse could play an important role. And here I'm thinking of, for example, the way Japanese accountability for past war crimes could well affect the extent to which that country can be seen as an Asian great power with a human rights alternative to China. We also see in an interesting development trade deliberations between Korea, Japan, and China. As mentioned in the earlier comments, there is now a UN probe of human rights violations in North Korea, and this was one of the steps that took place in the Middle East as well. So we are really, I think, on the maybe not yet on the road, but on the there's a step before the road, the creation of a space for a discourse of transition. I think it's important to recognize that accountability will have to be understood as something that doesn't take place within just one state, but rather regionally, and this may well point us in the direction of a lasting peace. Thank you very much.
We will now take a 10-minute coffee break. Our first session will begin at 1:45. Thank you.